Joining us on the program now, senior researcher from the Maxim Institute, Maryanne Spurdle. Maryanne, kia ora, thanks for your time.
Good morning, Andrew.
Is it on your list, people that you feel sorry for and need protecting, the vulnerable and feeble-minded in our society? Are Aussie banks on your list, Maryanne?
They haven't been so far. No. And according to the government isn't actually feeling sorry for them either.
Oh, good.
They're saying this is a necessary change because things are unfair. And it's slightly convoluted, and it relates to the things that they when you take out a loan with a bank, they're required to disclose the details of the loan. And if they make any changes, they're required to disclose those changes. And the banks know we don't read every single line, and most of us are not lawyers.
Yeah.
But you just, you look at the basics and you sign on to that. Well, from 2003, there has been the Credit Contracts and Consumer Finance Act, and they amended it in 2015. One of the things that the government decided was necessary was to say, if you don't disclose things, or if you make changes and don't disclose it to your customers, then you forfeit any fees and interest that the customer owes you during the period of the non-disclosure.
Wow, that sounds great.
Yeah, bank stuffs up, you get your fees back.
Yeah, that seems reasonable.
In 2019, they amended it because they're like, well, actually, that could be quite punitive.
Okay.
So it's now, the court's discretion as to what is fair and equitable.
Yeah.
However, from 2015 to 2019, that didn't apply. There's currently a class action that's been before the courts for 4 years now. It's been ongoing. 170,000 customers of ASB and ANZ who are owed something under this legislation. There is an amendment. Submissions closed yesterday. That's why I know something about this, because we put a submission in. And it's had its first reading. There are 3 elements of this amendment that are not controversial at all. There's a fourth one that specifically would say from 2015 to 2019, actually the rules post 2019 apply. The courts have to decide what's fair and equitable.
What?
Customers don't just automatically get back their fees and interest. Now, the interesting thing about that amendment is there's only one class action currently before the courts. There's been no sign of other smaller lenders being impacted by this. But the rationale is that this would impact competition in the market. This would impact banks' viability. So we must make this retrospective law to protect banks.
Well, when we say banks, we mean ASB and ANZ, because they're the ones who have the class action. Banks beginning with A, they could have put that in the section here. And honestly, this is a little bit of a retrospective get-out-of-court-free card for ASB and ANZ, who are in the middle of litigation, in the middle of a court process, to basically apply the law which was in place for a period of time. But the government is pulling the rug out from under this class action. Is this likely to mean, if it goes through, that the class action will fail?
Yeah, I don't know exactly what definitely will happen. No one does. But what it means is the courts will be compelled to figure out what's fair and equitable for 170,000 claimants.
Wow.
That's not a very simple class action at that point. For the past 4 years, as they've been going through the courts, it's been the rule will apply to all. If you get back your fees, you get back your fees. And it's looking very likely, because the banks did breach. ASB had an interest calculator that was incorrect. So there were people making decisions based on information that was not accurate, and it was advantaging ASB. Now, you could debate whether somebody should get all, whatever it is, 20 grand back that they paid the bank, or if really it didn't make more than $4,000 or $5,000 difference to them, but you're not going to debate that for all of those 170,000. And they cannot, this is the important thing, they cannot afford to take their individual cases before the courts, which is why the class action is necessary. And the funders for class actions, they take a gamble. They go, we're going to back this court case, and it's been going on for 4 years. So they've invested a lot in this court case. And then if the law changes retrospectively, well, the risk that they weighed up suddenly changes.
Wow.
And
And
going forward, this sets a precedent now.
it does.
So if
Not only is that a precedent, but in some ways the door's already shut on this one. So it's not like there's going to be an ongoing vulnerability for these banks to accidentally or on purpose not disclose changes in the terms of conditions. That door's already shut. It was just the people that engaged with those banks between this date and that date. And honestly, I'm not sure what to feel sorry for. Do we feel sorry for the banks having an operational monopoly here in New Zealand, or do we feel sorry for the record profits that they're making?
Yeah.
I mean, this will take away from their record profits, so much so that they might not be able to afford the lobbyists that have no doubt lobbied government members to get this clause put in the bill in the first place.
Yeah, and this is so there's the precedent. We really shouldn't have legal precedents where you can change laws retroactively. And there are a couple kinds of retroactive laws. There are ones that actually they're called remedial. They take away unjust penalties on individuals. And then there are others that are rights removing, and you don't want rights removing ones. It's the consumer that needs protection. It's not the banks. The banks knew the rules when they signed on. That was just the deal. The deal has changed now, and so they could be liable for less going forward. But that was the law at the time, and you've got a lot of people who've invested a lot in the way it was. The other precedent you don't want is one where lobbyists or other powerful entities think that the government is open to negotiating past laws and changing them. And what that would do is it would actually have a chilling effect on these kind of class actions, because funders overseas or within New Zealand would go, well, there's a precedent now that class actions, if they're going to have a significant impact on a large institution, there's a precedent now for changing things retrospectively. That raises their risk and it lowers the chances that they will back these class actions, which ultimately means consumers are worse off.
Yeah, certainly. And honestly, if you just look at what's happening here, if somebody's arrested for a crime, for example, if they've got enough money and they say to the politicians, hey, could you make it that this law that I've committed, that I'm obviously guilty of, could you make it that that's no longer a crime, and could you backdate it to the period of time where I committed that crime? I mean, that's a simplistic view of what's happening, but that essentially is what's happening, right?
Yeah. And the argument is there are small lenders, and it could come to light that some of them may have breached things, and it might be punitive for them.
But the small lenders can't afford the lobbyists.
All the government
ASB
needs to do is go.
Yeah. The small lenders can't afford those lobbyists, right? So ASB and ANZ are doing this as their benefactor. They're doing it on their behalf. No, they're not.
Exactly. Yeah, the government is. The thing is, all the government needs to do is go, what we're going to do with this amendment is say no further cases between 2015 and 2019, if they are discovered, can come forward. These ones were discovered by an investigation by the Commerce Commission.
Yes.
And both banks ponied up a few $1 million to say, there you go. And then this class action came and said, no, you're liable for more than that.
Yep.
It's probably going to be in the hundreds of millions.
Yep.
But I mean, they made, what was it, in New Zealand, ANZ 2.1 billion profit last year, ASB 1.4 billion, and the parent companies over 6 and over 9 billion. So, I mean, this is not going to damage their ability to continue operating. It's not going to diminish competition.
No, certainly it certainly isn't. Not between the five Teletubby Australian banks that we kind of don't really have a choice between here in New Zealand. Now, as you mentioned, Maryanne, you've put in a submission on this one. What's the process from here? Are you optimistic that that common sense and fairness and decency will trump lobbyists and large piles of cash?
Well, it depends how many people are aware of this. In the first reading, National and ACT were, very much, oh no, there's no lobbying going on. And then you've got a Labour MP, Reuben Davidson, said, well, I've been contacted. He said, many of us have been contacted by the banks. The banks are very good lobbyists. So the odds that The government hasn't been lobbied, very slim. New Zealand First, interestingly, they were cautious about. They did not throw their support behind this particular part of the amendment.
Yep.
So it depends who's aware. It's had the first reading. It's going to the select committee. I think they're hoping to wrap this up by October.
So New Zealand First potentially could pull the plug on this one. Winston could be the hero. Banks could be the loser. This is within the realm of possibility.
Probably.
Yeah. Okay. Well, we'll watch this space. Maryanne, thank you for explaining what is a complicated situation, and thank you for the work that you do at Maxim. Of course, maxim.org.nz for more information. Thanks for joining us.
Thanks, Andrew.
Hey, thanks very much for joining us in the Rhema studio. Thanks very much for watching the interview. It's kind of nice to have an audience, actually. And if you did like what you watched, then do give us a like, do give us the thumbs up. And if you'd like to see more interviews like that one, or perhaps even better, subscribe and those interviews will come straight to you. Don't forget to turn on your notifications, and we'll see you in the next one. Cheers.